Hi.
Good morning, sir.
Good morning. How are you, Vinesh? Oh, Asif,
Doing
how are
well.
you? Good.
Thank you, sir.
Okay. Dear friends, welcome you all to this session. Now, I hope you have gone through the presentation material on the three legislations like Standing Orders, ID Act, and Trade Union Act. I hope you have gone through in detail, all of you?
Yes, sir.
All of you, Tipanna,
Yes, sir. Yes,
Yes,
sir.
sir.
Avinash,
Yes, sir.
Bhuvaneshwari.
Yes, sir.
Okay, that's good. Now, what I will do is that since you already gone through, I will just highlight the important features of these three legislations in detail, in much, not much, but highlight the important fact. Now, thereafter, I would like you to ask me any questions for clarifications or doubts or anything like that. Please do not hesitate. Okay, so this is my request, and then let us make you this situation a really useful and a good value addition for you all. Okay, fine. Now I will start with the Trade Unions Act. Now all of you are very familiar with the trade union, whatever we talk, whatever we see in our day-to-day activities, and also you've seen it.
Voice is not clear, sir.
Beg your pardon?
Voice is not clear, sir.
Is not clear?
Yeah.
Now is it okay?
Yes, sir. Yes.
Okay. Now here, Trade Unions Act, as you know, it is 1926, and unfortunately, no amendments have taken place to this act now. No amendment have taken place. Whatever the act was there at the 26, same thing is continued even today. There is no difference. Of course, as you know, Constitution of Trade Union is only 7 people, and membership should be 10% of the workers in the establishment. With that, the registration, formation of a union, and registration can be done legally under the Trade Union Act. There are two things in trade union. One is the registration part of it, another is the recognition part of it. Registration part of it is a legal compliance in the sense that if a trade union is registered, then it becomes a legal body to negotiate, to do anything, whatever they want under the law. It gets a legal status it gets. Now, recognition at the moment, it is not legally mandated. Please be very clear. Recognition is not legally mandated as of now. It means that the management, what do you mean by recognition? Recognition is the management shall recognize the particular union to discuss and negotiate on any matter representing the workman in the establishment. So it is purely what we call the function of the management or obligation of the management to recognize a union. Till now, the recognition is not mandated. Of course, to certain any extent, the management can say, okay, I formed a union, but I shall not recognize. I'm not going to discuss. He can say that. There is no problem in it. But the thing is, recognition is not a legal status now. Hence, registration and recognition are two distinct factors. Of course, in the new labor code, which is going to get effect soon, there the recognition is mandated. It is mandated. Okay, now there's a difference. Of course, in the state of Maharashtra, there is an act called Mrityu and Pulp Act, where the recognition is already legalized a few years back. I think it is the only state in India to accord recognition to any union in a by law. It is in other states it is not so, but here what we do is by practice, by way of in order to have a cordial relation to the union, what we do is that the moment a union is formed and if only one union, then normally management will say, okay, come, we'll discuss. That's exactly what's happening in most of the establishment as on today. It means that even though there is no what you call a certificate by the employer that I'm going to recognize you, the very fact that the union is invited by the management to discuss, put up in demands, put up in this one, and they discuss and come to an understanding. And in most of the management, we have signed a lot of long-term wage settlements or anything like that. It has been done. So this is only an aspect of it. Just keep it in mind. Now, second thing is what is the protections given to the trade unions under the Act? What is the protections? Actually, there is immunity against civil suit on a union, and there is immunity against criminal actions against the union. They are mandated, but it is subject to certain conditions in the sense that if the union adheres to law and if it doesn't come in the way of rights of another person, then they have got there is immunity for them. I'll give you a simple example. Supposing the workers gather at the gate, shout slogans, but they do not obstruct the movement of the goods and materials and the managerial people to come and go. They don't obstruct the gate, then it's illegal. Then what happens? The management cannot sue or file a case against the trade union that shouting is bad or you can't creating a no, that is not permitted. But supposing the trade union blocks the gate, right, and obstruct the movement of the managers, obstruct the movement of goods and materials, if they stop it, then what happens? They are coming in the way of the right of an employer, the fundamental right of an employer to exercise his rights of coming in, going in, coming in, going in, and to carry on the business. That is the violative. Then what happens? The company can sue a union for redress. So this is one important. Similarly, in case of criminal activities, the union cannot get the immunity. If they indulge any kind of criminal activities, like for instance, damaging though they're outside or inside, and if they create any of assault on anything on the managers or with their own workers, if they create a law and order problem, then what happens? They don't get the immunity. So these two things are given by law: immunity against civil suit, immunity against criminal activities. It is given, but if they have to be legal, then what happens? The management cannot sue against them. So this is one aspect. Just keep it in mind. This is a limitation. Now, second thing is a question may come. Just because I'm a trade union leader, just because I'm a union, uh, am I immune to disciplinary action? Just because I'm president of the union, I can do anything, whatever I want. I'm a protected workman. I do this, I do that. If it comes, it is not so. Because initially, as far as the company is concerned, as an employer is concerned, at any trade union leader is an employee to start with. That's very important. It is a secondary activity. Formation of union, becoming president, secretary, blah, blah, everything. It is a secondary activity. The primary activity, he is an employee, then he is subjected to all rules and regulations and standing orders of the company. He is abide by that. He is not immune to that. Very, very clear. Even he is liable for transfer. He can be transferred to some other unit, and all that. The only thing is they should have bona fide reason. They should not be malified reason of the management. That's the only thing. So otherwise, the officers union are not immune to any type of disciplinary action, provided it's a fact what has happened. It means that it should be a union and a proper case built upon him. Then he has no immunity at all. Let's take the example of as a president of a union attacks one of the manager inside the shop floor. He attacks him. Then it is an act. Because it has got evidences, it has got everything is there. There is no malified on the part of the management. So what happens if the case is proved in the domestic inquiry, then he can be punished. There is no issues at all. So this, just to keep it in mind, this is exactly what is to be kept in mind in dealing with any. It can be office bearer, it can be executive committee members, or it can be anybody else. They are not immune to disciplinary action, provided we got a bona fide and a correct true case. That's the only thing. Now, second thing is what happens in outsider. Outside, even into the Trade Union Act, at the moment, one third of the office bearers can be an outsider. It can be an outsider. So, outsiders, if they are elected as one of the office bearer, if they're elected as one of the office bearer, how do they elect as an office bearer? Normally, what they do is that uh, they suggest the name of an outsider in the general body. They pass a resolution to admit that person as a member of the union. Got it? So he should be admitted as a member. Then only he can contest. If he's not a member, he cannot contest. So normally what they do is that by putting the bylaws also, that an outside member who will be admitted as an honorary member, then he will be contested in the election. He becomes the president, secretary, whatever it is. Then what happens? He become an office bearer of a union, and he can sit with the management for discussion, and management cannot deny because he is an office bearer under the act. He cannot deny. Now let us take the example of all the office bearers of a union or internal people, and they got a legal advisor. Normally, any union will take some legal advisor to guide them. A legal advisor is not an elected person under the Act. Got it? He is not an elected person. So he cannot be an office bearer. He cannot be office bearer. So a company can say, legal advisor, I will not invite him for discussion. Sorry. It is legally valid, it can be done. So many times it happens. Many times happens. So of course, some management, of course, if they're quite what you call broad-minded, okay, you come and discuss, no problem. But some management might say that no, I will take a legal stand. I will not allow legal advisor come. Means yes, it's permitted. It's by law. So this is the type of what you call the this thing. Any other formalities are they have to file the returns, they have to manage the funds, and they have to look up the fight for the benefit of workers, and all these allied activities will come, and there's the kind of thing. Of course, to tell you rightly right now, of course, there have been a change in the outlook of trade union nowadays on account of our modernization, rationalization, and the management have come forward to discuss the union, make them to understand development of leadership. All these things have been done by the management on account of a lot of latest development in the industrializations for last 10, 15 years. Now what happened? The relations between the union and the management has become a collaborative approach. A collaborative approach. Hence we go by mutual understanding, blah, blah, everything. So there is no problem in it. Now here, of course, even the Unfair Labor Practices Act, when I deal with the ID Act, I will tell you unfair labor practices. There are unfair labor practices on the part of the union also. It is mentioned. And on the part of the management also unfair labor practice. Supposing, I want to obstruct the form of a union, it becomes an unfair labor practice. And even, let us say, for instance, they have elected, the union have been elected, they have got majority of the entire thing, and still I say, I'm not going to negotiate with you. It is also called unfair labor practice. So there are certain things mentioned in the ID Act. Of course, probably you have gone through the PPT presentation in the ID Act. So in simple, this is about the Trade Union Act. Okay, this is about that. It's a simple, small act, but I told you already in the labor code, some changes are there. Changes in that the recognition. It means that recognizing the negotiating agent, correct? Negotiating agent, it has been recognized, and that the moment the code comes into picture, then afterwards we have to do it, and all those things we have to do. When we deal with the labor code, I can talk to you in detail about that. Okay, this is one thing. Now, secondly, now coming to the Industrial Disputes Act. Now, this is an extremely important piece of legislation for all the HR. Please take it in soon. And you have to be completely thorough with the Industrial Disputes Act, right from section number 1 to the last section. You have to be thorough with this because this is an act which all of us use this, and we should be aware of this in all our day-to-day functions in HR and labor management. So this is extremely important. So my request is that please study this act in depth. Whenever you get time, you must do that. Okay. Now, let me start with. Now, there are main 2-3 chapters, but I'll talk to you on the definitions. Definition, this is an important thing, what you should know about it. In the definition of industry, what is an industry is a definition. Now, earlier, of course, in my PPT also I mentioned that there are different interpretations by Supreme Court and earlier cases where about 20 years back or even 25 years back, industry means it is only purely industry. It means that hospitals are not industry, other commercial establishments are not industry, and service industries are not industry. They took literal meaning of industry. Thereafter, second phase came. Then they changed the view. No, industry means it covers everybody. It means that it is expanded to everybody, including education institutions, including hospitals. It should be. Then thereafter, again, there was a change in the set of the high Supreme Court judges. Again, they reversed it. So these 2-3 phases came, but till the famous case of BW versus Rajappa came, pronounced by one of the most eminent judges of our Justice Krishna Iyer. Now, in my PPT also, I have given a small expert excerpt of the judgment. Please go through that. The judgment given by Krishna Iyer in this case, that is the law even today. And in the labor code also, the same this thing have been incorporated in the definition of industry in the labor code. So what I mean by industry is a very simple definition. He has the theory he has evolved it here. What is it? There should be systematic activity in the establishment. There should be people employed. That's very important. People employed to transact between the business and the entire thing. They should the product or the output or the service should come out of employer and employee relationship. That's all. If that is there, it is an industry. Now, on account of this, what happens, ladies and gentlemen, the thing is that every activity, even an office, is an industry because office work is taking place on account of the cooperation of employees and the employer. People are employed. That's very important. If they're employed, it becomes industry. Any commercial establishment, it is an industry. An IT industry, it is an industry. A hospital is an industry. Education institutions is an industry. Now, coming to education institutions, there are two things. In education, so what happened? There are two types of staff. One is teaching staff, another is non-teaching staff. Teaching staff are not workmen under the IDEA Act. I'll come to the definition of employee at the time. I'll explain. They're not. So, IDEA Act is not applicable to teachers, whereas non-teaching staff, like for instance, the clerical staff or administrative staff or housekeeping staff, librarians, all these things, they fall under the definition of workman and industry. It applies for them. So this is how the whole thing is built up. So this is very important. Just keep it in mind. An industry is very simple, 3 formulas. That's all. So with that, now the judgment of Supreme Court have been followed right from the day of the judgment in 1991 till today. That is the basic thing. You should keep it in mind. The definition of industry. Now, coming to definition of workman. Who is a workman? That's very important. You must do that because this activity you have to carry out every day in your activities. Just be very clear. If you read the definition of workman, it's quite elaborate. A person employed for unskilled, semi-skilled, manual, blah, 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 everything. All these things have been mentioned. Exceptions are that if a person is engaged, if he is employed in the position of a supervisory and managerial position, supervisory and managerial activities, functions, drawing a salary more than 10,000 per month, then he is not a workman. He is not a workman. So, in order to be to define as a member, to be a member, he must be holding the activities or carrying out the activities which is not supervisory. So, what do you mean by supervisory? If you take the definition of supervisory, what it means that I have to supervise the work of somebody, then only it is supervisory. It means that I have to have subordinates under me. At least I have to have 3 subordinates under me. I have to 5 subordinates under me. So what I do, I direct them, I advise them, I get the job done, I direct them how to do, I guide them. And if they don't do, I reprimand them. And I got also powers to initiate action against them. I got powers to grant increment to them. All these things. So it means that you must be functioning as a supervisory in general. Then what happens? He is not a workman. So if you are friends in your day-to-day activities, you have to be very careful in doing that. Let us take the example of a accounts department, accounts assistant, right? Accounts assistant. Now, you take discrimination against him for some reason. Then please put up this principle. What is the nature of work? Nature of work. So nature of work is the criteria to decide. Supposing that assistant, he is doing normal clerical work, he don't have any subordinate under him, then he is a workman, right? Let us take the example of a supervisor in a shop floor or in a department or in a department, supervisor. When you want to examine him, please find out whether they got subordinates, whether he is actually doing supervision job. Examine it before you start taking action against him. If he falls under the definition of workman, even though he is called as supervisor, even though he is called as supervisor for the sake of position, but he doesn't have any subordinate, then what happens? He falls under the definition of workman, then you have to be very careful many times. So let us take the example of manager. You call him as a manager for all purposes, fine. But if he doesn't have any subordinates under him, and if he's not doing a supervisory job, then what happens? He is the workman. He is not exempted. So even though he's a manager, then what happens? If you have to take action against him, you have to consider all the facts required for as what you do for workman, you have to carry out the same thing. Otherwise, what happens? The courts will say, he's a workman, you not followed the principles, take him back. Because there are a number of cases happen, a number of cases. Take the example of a software. Take the example of a software engineer in a company. Software engineer. Software engineer, he is not doing any supervisory type of job. He is sitting alone. He is doing everything on his own. He will do it. No subordinates under him. Then what happens? He is a workman till today. Till today, all the courts are held that a software engineer is a workman. But let us take the example of team lead in a software company. Team lead. Team lead, what happens? He has got a batch of software engineers under him. The 3 or 4 or 5 or 6 under him. So what happens? He directs them, controls them. He does it. Then what happens? He is not a workman. He is not a workman. So friends, why I am telling this point is that normally you people come across these issues in your day-to-day activities, day-to-day, whenever you have to take action, this comes in the picture. Hence, always scrutinize it thoroughly before you take any action. The company may say, no, he's a manager, sack him right now. He may say, but it's for you to go into details what is the nature of work. If his nature of work is not supervising, then he becomes a worker. If he becomes a worker, you have to follow the process of disciplinary action as mentioned in the standing orders you take. Otherwise, what happens? The termination becomes illegal. So just keep it in mind. This must be take care of it. This is one important thing. Now, of course, the definition of dispute is very simple. A dispute between the management and dispute between anything. It can be what you call increment, promotions, wage increases, dismissals, discharges. All these things may be dispute. But one thing, just keep it in mind. Dispute in IDEA is a what you call a in plurality, in the sense that an individual worker cannot raise a interest dispute that I not got my increment, I have not been promoted, or I have not been populated. He cannot raise a dispute. Individual cannot dispute. Only the trade union can raise a dispute against him. That's the only thing. If the individuals are allowed to raise a dispute, you will have plenty of disputes in your factories or establishments. To allow for that purpose, they have recognized that the dispute must be raised by the union, not an individual. An individual can raise a dispute only after he is dismissed from the services. Let us say one worker has been dismissed. Then under Section 2A of the Act, then he can raise the dispute directly without the union. He can do. There is only one case where individual can raise a dispute. Otherwise, yeah, they cannot raise a dispute at all. So this is a dispute, and this is how you should just understand. Just keep it with you. That's the only thing. Now coming to the purpose of ID Act, to resolve the disputes between the management and the union, and to see that a proper interrelations created. That is the objective of the Act, as you know. Now here, the next thing is redressal of disputes. How do disputes are attended? Now, first of all, the first step is, of course, we call it as conciliation. Here, the conciliation is that when a dispute is referred, the conciliation officer is bound to hear both the parties, right? And the conciliation officer has got all powers to summon documents, and he has got powers to summon witnesses. He can do it, but he has no authority to pass any order. It is very important. Just keep it with you. A conciliation has no powers to issue order, except that he is empowered to only mediate between parties, right? He has to mediate. He has to use his influence to convince either party to come to a settlement. That is only his job. He has no powers to order anything on both the parties. He cannot order. That's not legal. Now, let us say, for instance, a dispute is raised, conciliation conceals it, then he is able to bring the parties to a settlement. Then the settlement is signed before him. It is under Section 83 of the Act. Then it is a tripartite settlement. It is binding on everybody. It is signed before the conciliation officer. Then supposing the conciliation officer is not able to bring out a settlement, then what happens? Conciliation officer has to record the failure report and forward it to the government, respective state government. The government, on seeing the report, if it consider this a matter to be referred for adjudication, they will refer. Under Section 10(1), they will refer. It means that the case will be referred to either labor court or industrial tribunal for adjudications. Then when the matter goes to the court of law, like tribunal or labor court, then the for practice will start all litigations, both the advocates and all the court process will start, and it will be this one. A judgment is called as award. The judgment is called as award. Award is binding on both the parties. Award is binding on parties. But supposing either party feels that the judge has committed an error, a constitutional error, not considering certain fact, if they got that point, they can go to High Court in an appeal. High Court could appeal, and High Court will adjudicate the matter. This is about the adjudication process. Now, in the meantime, there is one more machinery. Yet one more machinery other than adjudication that is called as arbitration. Arbitration. That's also it. So arbitration, what happens when a conciliation is pending? If both the parties come to an understanding, sir, instead of going for adjudication, we'll go for arbitration. Arbitration is appointing a third person as an arbitrator, and both the parties have to sign an agreement for arbitration and submit it, and arbitrator will be appointed because the number of arbitrators normally a legally qualified person, maybe many times, they're all retired judges of high court, judges of various courts. They are the arbitrators. Then we refer to them. The advantage in arbitration is that it's a time-bound process. Both parties can agree, sir, please arbitrate this matter within a period of 6 months. Arbitrate this matter within a period of 12 months. Then what happens? The arbitrator will complete the process or our stipulated in the agreement. Then what happens is a speedy settlement of dispute. This is the advantage. Whereas if you go to a court, as you know, you all of you know that in courts it takes what years together, 6 years, 7 years, 8 years. It goes on. It goes on. But in arbitration, this thing is important. So this is how the process of what we call resolution dispute. This is the machinery given under law under the ID Act. Broad thing I'm telling you, but in detail, please study the PPT. It will give you a lot of information. Okay, number one. Now, come into the strikes and lockouts. Now, here at the moment, public utility services, some your services have been declared as public utility services by the government. Take, for instance, the water supply board, or even our transport industries and telephone departments or railways or anything. They are all declared as public utility services. If they're declared as public utility services, they have to mandatorily give 14 days notice before they go on strike. This is very important. The moment the notice is given, the conciliation has been deemed to have been started in public services. The moment the notice of strike is given, because normally what happens, a notice of strike will be given to the management and a copy marked to the concerned conciliation officer. Then the moment it goes, the conciliation has been deemed to have been started, and during the process of conciliation, they cannot go on strike. That's why to not what called safeguard the public against facing sudden strike, lightning strike by public services. So this is the protection given by law. And some of the industries also have been declared as public services depending on the nature of business and etc. etc. For non-business activity, non-utility services, then here what happens, if the standing order stipulates that 14 days notice shall be given, they have to give 14 days notice. Otherwise, it becomes it becomes a legal strike. Then let us say there is a subsisting settlement in the union, previous settlement in the union, where in the settlement it is mentioned that the union shall give 14 days notice, the management shall give 14 days notice before. If there is a clause in the settlement, then what happens? That becomes a contract of service. Then again, you can't go on a strike for the purpose. And if the strike is on account of an item already covered in the previous settlement, if they go on strike, then it becomes an illegal strike. Take, for instance, let us say the simple example of a house rental alliance. House rental alliance. This aspect has been previously agreed in the previous settlement, and it has been mentioned very clearly that HRA feels so and this is valid till the currency of settlement, if there is a clause. And in the meantime, the union changes and they, okay, sir, previous agreement HRA is not enough. We are going to raise a demand. You must give us double the HRA, and if you don't give it, we'll go on strike. If they so that it becomes totally illegal because that item has been covered in the previous agreement. So this is very important. So just keep it in mind. These are the circumstances where the what you call the strike becomes illegal. Strike becomes illegal. Otherwise, if they're peaceful strike, yes, they got. So the Supreme Court has been very clearly that going on strike is not a fundamental right. Please remember this. The union may say, sir, we have formed a union. It is a right to go on strike. The court says, yes, you got a right. Right means a legal right, but not a fundamental right. Right? It's not a fundamental. You got a legal right, provided you follow the principles of law. What? He has to give notice of strike. Then the concessions will start. They should not go on strike. And if the concession ends in failure, then before adjudication, again they can't go on strike. So even if they go on strike, it should be a peaceful strike. Peaceful strike. As I said already earlier, any violent strike, the trade unions have no, what do you call, shelter, have no immunity. The company can take action. So what happens? These kind of things, if it's a legal strike, the legal law will say, yes, it is a legal strike. Justification is a different issue. Legal strike. So under these circumstances, we call it as legal or illegal strike. And similarly for lockout also. Similarly, lockout also, there is no difference between this and the same principles will apply here also. Only for lockout, there is one, this one. Supposing the strike is illegal strike. Like I gave the example of HRA. During currency clearing settlement, it is there, and the workers will raise a dispute. They go on strike for this. Basically, it is illegal strike. And if the workers go on illegal strike, and the company can declare lockout even without giving the notice, they can declare lockout because lockout is justified, preceded by an illegal strike. Let us say for a lockout is invalid because let us say there is danger and apprehension to security and machinery of the company, then the lockout declared is justified. Right? Let us say, for instance, they damage the machinery inside the shop floor, or they want to threaten the people. They threaten the officers of the company inside the premises. Then in such case, if they don't declare lockout, it is an apprehension of danger to people and property. At that time, if the lockout is declared, then it is not an illegal lockout, it is a justified lockout. So this information, just here also I've given a lot of case laws in my presentation. Please go through all this strikes and lockouts. Now the next most important, gentlemen, is that the what you call Section 9A, change in service conditions. This is very important. Always you should bear it in mind. Change in service condition. If there is change in service condition, unless you give notice of 21 days, you cannot make a change. So what is it? What is change service conditions? In the schedule of the ID Act, it has been listed down. What are the activities? What are the activities? Now, for instance, normally we take, we go on for rationalization, right? Or improvement in production, automations. We do all these things. Then what happens? This amounts to change in service conditions. Because I am working in a particular fashion, I am working with this kind of a system. Now, if you want me to make more, there is a change in service conditions. So here what happens, the questions will come, Section 9A. Here normally what we do, in order to avoid the Section 9A, we discuss the union, we negotiate with them, you convince the workers, we convince the workers, arrive at understand, then effect the change, then Section 9A is not required. What Section 9A says? That if the service conditions proposed to be changed is discussed with the workers and an amicable settlement is reached on account of this, then notice is not required. So this is very important. So in your case also, let us say sudden company may say, no, please reduce the quantum of leave or rationalize the leave facilities. You are given 30 days, 35 days, whatever it is. Now you have to rationalize the leave, make the what you call earned leave less, earned leave just equivalent to what is given under law, and then the increase or decrease number of leave. What they may say so many things. Then in such cases, this Section 9 comes here because this effectively changes service condition of fine. So this is a very, very important issue. So this you have to keep it in mind always. This is very important. In some of the companies, what they do is that, let us say in my letter of appointment, it has been mentioned that I have to give 1 month notice before I quit the job. Suddenly, company informs everybody, no, you can't give 1 month notice, you have to give 3 months notice hereafter. Then what happens, gentlemen? This is a change in service conditions. Because in my letter of appointment, you have mentioned as 1 month. Now you are telling 3 months. It means that you are altering my service condition. Hence, you have to give notice and NDA. So all these things will come. So, gentlemen, keep this in mind because normally in all our day-to-day activities, something other will be coming. So whenever you want to execute this, do this, be thorough with this particular provision and the related cases. Related cases. I think I will give my PPT, I have given a number of case laws on this Section 9A, and also read along with the schedule of the Act. Schedule of the Act. Even some funny case I can tell you, of course, time is running out, but I can tell you what happens in one of the case. Normally, a thali, the canteen, consists so many items, right? Some 2 vegetables and pickle, puppet, and this thing, that thing, so many things. And one day the management said, now the cost is increasing from tomorrow onwards. You cut off 1 vegetable and 1 puppet. Then, believe on friend, this become a dispute raised by the union, and it went up to High Court because they changed the condition. What is my change something? I was getting full-fledged thali with 2 vegetables and puppet. Now you are taken away one thing, it almost changes service condition. So like this, there are so many things can happen. This is a simple example I'll give you. So keep it in mind. It is very important. You should keep it in. Now coming to layoff, retrenchment, and closure. Now here there are 2 things. One is Chapter 5A. Chapter 5A is applicable for the number of workers, not employees. Number of workers. Worker means I give the definition of workman, right? I give the so if the number of workmen is less than 100, then Chapter 5A is applicable. Then what happens here? You can lay off people, you can retrench people, you can close without seeking government permission. You got liberty. But supposing you have got more than 100 workmen, then mandatorily you have to obtain permission from the respective state government for layoff, retrenchment, and closure. So this is a major hindrance for the business. Now, of course, the proposed new code which is going to come, the 100 has been increased to 300. That we have to see how far it is going to take place. It may be beneficial, so it is going to be there. So this is the only difference. And then layoff, there are 2 things here. There are 3 types of wages. In ID Act, there are 3 types of wages. Please keep it in remember very clearly. Layoff compensation is paid on only basic and DA. Basic and DA. And then retrenchment compensation is paid on full gross salary. Closure compensation is paid on full gross salary. On 1 month's notice prior to dismissal or prior to retrenchment, 1 month, that's called 1 month salary in lieu of notice. That is called again gross salary. So there are three types of wages in ID Act. You have to always keep it in mind. Remember this. You have to strictly follow all these things. Okay. This is one thing about the retrenchment and the layoff form. Layoff, you have to do this. Now coming to the protected workmen. Protected workmen, there is a chapter. Here what happens? The union has the right. Union has right to seek protection from the management against unilateral dismissals by the management or punishment by the management. How many people? It is limited to 1% of the workforce subject to a maximum fine. So office bearers can give a letter to the management before 30th of April, before 30th April. If they give the letter on 1st, it is not legal. If they given on 3rd of May, it is not legal. They have to give before 30th April. With this number, the management shall recognize as protected workmen. Okay, what do you mean by protected workmen? The only protection is that here, if a person is he has created some, for instance, he has assaulted one of the managers, one of the unit leader. I told you already, he's not immune to discrimination. So you issue him a charge sheet, you hold an inquiry, you prove the inquiry in all the principles of natural justice. Your inquiry report is ready, and he is found guilty. You have to dismiss him. So what happens if the dispute pending, if the conciliation or in the tribunal or in the labor court, then what happens? The management has to seek permission prior to dismissal, seeking permission to dismiss before the authorities. So that is the only protection, in the sense that at that time authorities will go to the entire report of inquiry. If they are convinced the inquiry is fair, genuine, and properly done in line with the principle of natural justice, then okay, they give permission to dismiss you on the dismiss. So this is the only thing, otherwise there is no protection at all. So protection means, it does not mean he can do anything whatever he wants. It's only limited protection. This is the only thing is important. Other things are fine. Now, I've given a very short brief of ID Act. Of course, it's a very, very voluminous act. If I had to talk, I can talk for the 8 hours on this topic. But in my PPT, I have given you elaborate presentation material. Kindly go through that. I've given a brief of important aspects of ID Act. I've given you this. Now, coming to the standing orders. Standing order applicability, as you know, in current it is 100 or more. In ASIF, I don't know, in your state, I don't know how many, what is the limitation, is 50 or 100, just find out. Do establishment, the applicability of, in this employment standing orders becomes applicable. Then there is a model standing order prescribed in the schedule also. And within 6 months from the date of act coming into effective for a particular industry, then they have to submit for certification of standing orders before the authority. They have to prepare the draft, and they have to either discuss the union or submit a draft to the union and submit the entire thing to the certifying officer. The certifying officer will call both the parties. He will discuss each and every clause in standing orders and they'll bring to an understanding, and everything goes on well, he certifies the standing order. Once the standing order is certified by the certifying officer, then it becomes a legal document. Okay? Even, the standing orders, once certified, can be amended also. It is not that it is a 100% document also. No, depending on the change, depending on circumstances, either the management can apply for amendment or the union also can apply for amendment. It's quite possible. Then amendment of same process. If I have to amend the certificate standing order, I have to give a copy to the union, I have to copy to the certifying officer. The certifying officer again will call us. He'll say, what is the amendment? Why this amendment is required for? What is the reason for it? He hears both the parties and accordingly he gives approval or disapproval, whatever it is. So this is the thing of standing orders. And of course, I request you to, of course, most of you may have standing orders in your company. But one thing, friends, is that please be thorough with the standing order right from page number 1 to last page, because it's very important, because every day in all your activities, the standing orders is effective, right from the entry of a worker, right from he goes out of after the work, between this period, he is governed by the provisions of your standing orders. So you have to be thorough with everything. It may be attendance, it can be leave, it can be act of misconduct, it can be anything. So you have to be thorough with all these things. Now, of course, in the coming labor code, they have increased the applicability to 300. Again, 100, 300. Of course, this is what happens for the existing industries. This will not help. So let's say you got a standing order already, then you can't help it. You have to honor it. For new industries, this is going to come. Then probably that will apply 300, but not now. Because for you all, you already covered under the existing law, and you got a standing order already. If you have all that, then it goes on. They think there are no changes. So this is about a small, brief thing on the standing orders I've given you, and it's not a very major law, but practical aspects is very important, because here, domestic inquiries, how we should conduct domestic inquiries, it has been listed in the standing orders. You have to adhere to the principles of natural justice. And what is the language of inquiry? It will be mentioned there. And to assist a accused person, charge sheet person, to avail the facility of a co-worker, it may be incorporated in the standing orders. So these aspects you have to keep in mind for application and everything. Okay. Now I have given you a brief of a quick brief of three legislations. Probably you have got the, I told you already, you have got the PPTs. Read it once again, understand it, and then apply this entire thing. I try to give you a brief presentation of these three acts. Now, I will ask you for open house. You can ask me any question, I will clarify it.
Sir, good evening, sir. This is Prabhu.
Tell me, Prabhu.
Sir, can a protected workman can be terminated with approval petition with the past case history, sir?
See, whatever you can do, but one thing is, if there's a dispute pending, then you have to apply for permission for him, permission before authority. Then you have to prove before authority that I complied with all the principles of natural justice, I have conducted the inquiry and the country report, and he has to give permission.
No, those all inquiry and all done. He has proved that he is guilty.
Good.
The employee is guilty, but management taken a call. Okay, let him work.
Let him work.
The past cases. In the past cases.
In the past cases. Okay.
Yeah, in the past cases. While working, there is a dispute with the management and with the workman. So management taken a call that we can terminate him because he is giving unnecessary regards to the management.
Regards means in what way?
Saying slow down the work. Doing making unnecessary comments against the management.
No, that will
inside
not
the plant.
No, they should be very specific and clear. Let us say, for you to give the example of slowdown. Supposing he openly instigates the worker in the shop floor. Openly instigates. Look, friends, on account of this, please slow down the activities from today onwards. And the production comes down. And if you got evidence for it,
Yes, sir.
Then you have to charge sheet him for that. You have to charge sheet him for that. Then
No,
hold
if
an
the
inquiry.
same case happened in past also,
Doesn't
and that has been
matter.
proved also.
No, doesn't matter. Doesn't matter. But now your action is on the present case.
Okay.
Previous case, you have pardoned him. You accept his guilt. You allowed him to. It means that you have given him an opportunity to correct himself. That is the idea. It is a bona fide. But now here you have to punish him on the present activity. The present activity is what? He has done this. For this purpose, you can't take an emotional decision and discharge him because the court will never accept, because there is no specific charge. For this purpose, what you have to do is that you have to build up a case. It means that you have to prove the case. I'll give the example of instigation, or he can do anything, whatever he wants. Then in such case, you have to issue a charge sheet to him, quick and hold an inquiry in line with principle of natural justice. Then at the time of dismissal, quote all the previous cases. Quote all the previous cases in strength of your dismissal. Then if there is a dispute pending, then you go for permission. If there is no dispute pending, I repeat, if there is no dispute pending before the conciliation, if there is no dispute before the labor court, if there is no dispute before the tribunal, then after the inquiry, you can dismiss straight away, provided all these things are done. You can do it.
Okay, sir.
If there is authority, then you seek permission. Otherwise, no need. But be very careful. Please don't go by the words of the management to say, I want to sack him. Please don't go by that. You go by this. You follow the process of law. Otherwise, you will have a bad picture.
Okay, sir. And one more doubt, sir. What about dual employment, sir?
Actually, dual employment is not permitted. Not permitted. Because even in the Factories Act, it is not permitted. For this purpose, you have to take what you call issue a show cause notice to him. Why action should not be taken against him, and what is the nature of dual employment? Is there conflict of interest? Is he working in the same type of industry, whether he is working with a competitor or some other industry, whatever it is, you have to issue show cause notice to him and take action against him. Again, here also, friend, what you have to do is that issue show cause notice, seek explanation from him, hold an inquiry, and take any action. Dual employment, yes, it can be, but provided you follow all these things.
Because why I'm asking, in my previous company, one of the workmen was doing that Deepavali cheat inside the premises.
Oh, then no, that is
And
not.
that has been proved, and under his name only was that financial activities and all done.
See, that is not. Oh no, please don't mistake me. Then that is not dual employment. It means that he is carrying out a business during office hours in the premises of the company. It is a serious misconduct. It is not
Actually, that
dual
was
employment.
double.
Dual
Actually,
employment.
it was double charge sheet, sir. One was during working hours, he was doing his personal and business activity in the premises, and he was doing one more business outside.
Outside is different thing. Now concentrate on the what he is doing inside the premises. Outside, what happens? Outside, what happens? That is fundamental right to anything, whatever you want, sir. But inside the factory,
sir, during rest hours, he has to take the rest, but he is not taking proper rest, and during the working hours, his work was affected. Our management, that management was climbing on that way.
That's it. For that purpose, you focus on internal work. That he is doing personal work for his personal gains within the factory hours, being an employment in the company. That's all. With that, you can make a strong case and dismiss him. Please do not quote outside. We may prove, we may not be able to prove. That's a different issue. That's not worry. But fully
if it is proved,
sir, if it is proved, you can do it. If it is proved, but difficult to prove many times. It's difficult. But here inside the factory, it is very easy to prove because you got witnesses, you got evidences, you got documents. To say that he is carrying out personal work in the factory by ignoring the normal work, you got a lot of evidences. You can do that. You can sack him. That's always that's going to be upheld. You have to make a distinction.
And one more doubt, sir. Actually, one of my previous company, one of the worker on his name, he has taken a one passenger auto. And in that registration, auto registration RTO book, that was mentioned his name as a driver. So management claimed that he is the owner of the passenger auto and he is the driver. So he is doing a dual employment basis that management taken he has given a charge sheet and he was inquired and that has been proved, and the case was still under labor court. Whether it is
Now, that's a difficult case, because what happens is that, you see, just because he is a registered auto driver and then he is doing the auto after the working hours, after the working hours, if he is doing his own business, then the courts will not support you. But supposing he is doing the auto work in the factory, when in factory, he anonymously, unauthorizedly remains absent. Unauthorizedly absent and he drives auto. Then suddenly he goes out of the factory, he drives auto. If it comes in the way of your day-to-day activities, normal activities, then you can charge him for this work, not for driving the auto. But driving the auto, let's say he works sincerely 8 hours and then goes out and drives an auto, the courts will not support this. Courts will say, it's not a case for dismissal.
Okay, sir. Thank you, sir.
Okay, thank you. Mr. Asif, any questions? Avinash?
Sir, I have some small doubt, sir. As how do we regard the persons slow down their work in the floor? Like,
yeah, that's very important. Here, what happens is that for this purpose, see, if it is a manufacturing unit, it becomes very easy because you have got production, day-to-day production records. You have got job cards. You got everyday activity of a person. It means that, let us say he's supposed to make 100 components and he has been making 100 components in a shift. And supposing, let us say, for various reasons, he brings it down to 60 components instead of that, and then you got record to say that 60, then what happens? It's a willful slowing the work. For that purpose, you can charge him. And for other activities, sometimes, the activity can be not on quantum of work, not on number of pieces, negligence of work. Let us say he's supposed to carry out, let us say, 8 projects every day. 8 projects he is supposed to assign, 8 assignments he is going to do. But he was doing it. But today he is carrying out only 4 projects out of that. It means that he is willingly slowed down. Like that, you should quantify. That's important, because you cannot be vague in saying that you reduce the work. The law is the principle of justice is that the charges must not be vague. It should be very, very specific. The charges must be specific and must be objective, not subjective. So here what happens, you need to quantify. If you don't quantify, then it is gone. I will give a simple example of HCL case, what happened in Chennai. He's a software engineer. He was dismissed, just issuing a show cause notice. He is not even show cause notice. They terminated him for low performance. They dismissed him. And the software engineer challenge when the Madras High Court asks, you say low performance. What do you mean by low performance? Have you quantified it? Have you asked him? You are supposed to do this, you have done this. What is your opportunity given to you? So all these questions will come. Here in slowdown practices, slow practices, most important thing, Mr. Asif, is that you must quantify. You must quantify. Any work you can quantify. There is no doubt about it. But you have to apply your mind and then quantify, then subject him to all these things, then have a good case.
Good evening, sir.
Okay.
Sir, I had a question. Sir, with regard to flying the union flag, can the union demand to raise its flag any place, or is there any specific section in the law?
No, actually, there is no specific in the law. But the thing is that the principle, legal principle is this. They can hoist the flag not in the premises of the company, that's all. Because the premises of the company belongs to the employer. The union cannot trespass into the property of the company by hosting a flag. It is not valid. Even the courts have held that if you hoist a flag, please do it outside the premises, not inside the premises. If they do inside the premises, unless they seek permission from the management, or if the management says, I will not allow you to hoist the flag, they can't do anything. So this is very important. Anything must be outside the premises of the company, because it amounts to trespass. I mean, trespassing into your house and then doing it is not legal. The company can seek an injunction against the union in doing this, because I told you already in Trade Union Act, if the union adopts a principle of coming in the right of another person, then they don't have immunity. Here what happens? Let us say somebody comes to your house and say that I want to put up a flag in your house. Will you allow that? It amounts to trespass, right? Same principle. So that you can do it.
So sir, if they insist that we want to put the flag on the main gate, not entering inside the gate, but on the main gate, they want to fly it on the main gate.
The gate belongs to whom?
Right.
The gate belongs to the company, right? It's the property of the company. You can't.
So that is not allowed.
That's not allowed. It is not at all allowed. It's not allowed.
My second question is, sorry, sir.
Please.
Sorry, sir. Yeah. Sir, my second question is, sir, in the Trade Union Act, which has now been replaced by the IR code, if I properly recall, 2/3 of the members can be outsiders. So, sir, why is that 2/3 of people are being allowed to be in the union who are of outside origin?
Yeah.
I don't get the logic, sir.
No, you see here there's no logic, because the history of trade union history, because what happens, the earlier days, the union expertise. You must get the expertise from outsiders, because we are not legally strong. We don't know what is legal or illegal, and we don't have the powers and ability, all these things. So for that purpose, this is the history that has come here. In history. Now what happens, unfortunately, even under the code also, the government was unable, or even the company was not unable to, in fact, all the employees resisted this. They said outside should not be allowed to participate in the union at all. That was the stand. But upon history, of course, they made a deviation. We can't help it. We have to accept it, that's all. You see, normally what happens, even though I mentioned 2/3, it need not be 2/3. Normally, if you see any union, normally one will be there. Predominantly one we see. That's all. Not
that
more
outsider
than one.
can be anyone, sir, or he has to be connected.
Anyone, but you should be elected. I told you already. He should be elected person, electable. Otherwise, he will not be a union outsider.
That my third question is with regard to the definition given with regard to notice of strike. So, sir, there are 3 conditions given. one condition is very clear that 14 days notice has to be given. There are two more things which are very confusing, sir. So,
two more things.
may I specify what is confusing?
What is confusing?
Just a second, sir. I'm just taking out the section, sir. It's mentioned as before the expiry of the date of the strike specified in any such notice. So what does this mean, sir? Before the expiry of the date of strike?
The thing is like this. I give a notice of strike. I shall give notice of strike of 14 days from today to so and so date. Let us say he has given the first of this month. So he has to start the strike only after 15th. Got my point? Supposing he starts the strike on 12th day, then that's illegal. That's the point what they mentioned in the section. Before the expiry.
So expiry, before the expiry of the date of strike means essentially which date it would commence. The strike would commence.
Exactly. If we start after 14 days, then it's no problem. But if he's coming the strike within that 14 days, then it's not a legal strike. That's what section says.
The second thing is without giving to the employer notice of strike as hereinafter provided in 6 weeks before striking. What does this mean?
Exactly. Suppose you are giving notice of strike today. I sleep over the matter for 8 months. I don't do anything. After 8 months, I say, I give notice already, now I want to strike. That is not permitted. Even for that also, law has put a limitation. So within 6 weeks, you can't be a permanent notice you can give. You can be open-ended notice. That is the purpose.
Suppose I give a notice of strike to, on the 1st of August. From the 15th onwards, I would be allowed any day after 15 till 6 weeks.
Yeah, no, not 6 weeks. You can give it, but let us say 1st August you were given the notice.
Yes, sir.
6 weeks, when it is going to expire?
Expiring on
September.
15th of September. 15th September.
So after 15th September, he cannot go on strike.
But I can go on strike from 15th August to 15th September, any day.
Yes, exactly, any day. Because the intention is that one cannot give an advance notice of strike and put the matter into trouble. That is the reason. You can't say, I will go on strike for up to 6 months or 8 months. No, there is the reason. Yeah.
Thank you, sir. Thank you.
Yeah, good.
Sir, I have a small doubt, sir, about union. Is there anything is employee recognized, registered one as recognized by the employer? In any cases, employer be suspend the union, not recognized by the employer in any case?
No, it's not like that. See, the employer can say, okay, I will not recognize you for discussions. He will not. But they are not prevented raising a dispute. They can raise it because a registered union. A registered union can always raise a dispute. Right? He can raise a dispute. So that he can't. And also, under ID Act, it is an unfair labor practice. If you, of course, they say recognize union, but what happens? The courts also will ask, why you are not talked to the union, though it's not legal binding, not talk to the union, but you can't dismiss the union straight away like that. You can say, okay, I will not discuss with you. That's all. I will not recognize, I will not discuss with you. Many times it has happened. It has happened.
So suddenly we be given any in matter of letter or something as not recognized means?
No, we will not. Normally, better not to give any letter in writing by the management. You should not give it. Because what happens, your
going to
surrendering
legalize
yourself that I am not
surrendering
going to
myself.
recognize you.
True.
That we
True,
should not
true.
do. By implications, by overly, we should say, sorry, Baba, I'm not going to talk to you, I will not discuss with you. That's all.
Okay.
Yeah.
Thank you, sir.
Yeah. Okay, friends, I think.
Sir, I have a question, sir.
Yeah.
Okay. Sir, my question is, before strike, giving notice to management. Okay, for example, without notice, without any information, union they started strike. For example, in half a day. Okay, half a day they made a strike. After that, they realized no, not to do. Then they go back to their work. They started work. Okay. As a management, the after day what they bear, it is loss to management. That loss, then salary, management can decide to not to pay.
Yeah.
Is it valid, sir, or it is
definitely?
Is it
No. Definitely, because law is very clear. Even the Supreme Court also has said very clearly. The principle is no work, no pay. Even if they strike for 2 hours, no pay. You can deduct is valid, acceptable by law. There is no problem with it.
Okay.
Yeah.
Okay. Clear, sir. Sir, I have one more question, sir.
Yeah.
It is related to standing order. See, for example, after recognized by the management, union, okay, but before union forming, standing order is already approved. Is it required to amend standing order again?
No. I told you already. Once the standing order is certified, it is a document.
Okay.
Only union can, if they want to amend a clause, they can apply for amendment. That's all. Otherwise, nothing can be done. Nothing can be done.
Okay. They can't demand to amend. They can't demand to union.
No. If they want to amend a particular clause, they can go for amendment. Otherwise, nothing. Yeah.
Okay. Or particular clauses. Okay.
Only particular clause.
Understood.
Yeah.
Understood.
Prakash,
Yeah.
I have
Thank you,
a
sir.
question.
Tell me, Prakash.
Sir, so you spoke about unfair labor practice. So, in case if you want to implement, a two-way structure, or maybe different salary structure for the existing employees and for the new employees. For example, basic is 40% for the existing people, and also new joiners 50%. Is that allowed, sir, in same organization?
No, that is allowed, because I tell you, the thing is that I'm employing a person with an understanding that your salary structure is so and so. And he accepts your employment contract.
Okay.
And he signs it. That is not change in service conditions.
No, but in the same organization, if you have different benefit for different people, I mean, for example, let's say existing people.
No, that's a different issue. Then what happened? That's the major issue. Major issue in the sense, let's say, for instance, you got set of people with same qualification, same experience with so and so salary. And you got a set of people, same experience, the same this thing with different salary. Then what happens? It is what is called, more than a law, it is an internal employee relations issue, in the sense that you can't have a discriminatory service conditions for two sets of people. That can be the issue. So what happens, if there is a union, they can raise an issue saying that the management is resorting to unfair labor practice by adopting this system. They can raise an issue. That's all.
No, the salary band are maybe based on the levels and experience.
That's what I'm telling you.
But problem is the benefit. For example, existing people 40% basic, they will also get less retirement benefits. Or maybe new joiners, if they're getting more basic, then again their retirement benefits is more. Is there any dispute, sir?
No dispute. Because I tell you, I told you already, it's only purely based on your employment terms, employment contract signed with him. That is always binding. We can always. Overall, there is a different issue. But the individual is concerned, he cannot do anything on that. There is no question of that.
Okay. The second question is, sir, because even IT, ITS are exempted from the standing order now. But still, in case if you want to terminate somebody, we should follow the show cause notice and also investigation.
Definitely, because I give the example of software engineer. He is a workman under ID Act. If you dismiss anybody without the process of law, it becomes illegal. You have to follow, even though there is no standing order, you have to follow the principles of natural justice. You have to do it. That's very
in the new wage code also it mandates standing order for the IT.
Yeah, definitely. No, there an option has been given to the state government to exempt. Now, for instance, Karnataka government, they have exempted IT, ITS. So similar provision has been made in the code also. If the government wants to exempt, they can exempt. They given a provision. So in the code comes also, if the government Karnataka says, okay, I will exempt, then the matter is over. That's all.
Okay, so last question. I think you spoke about worker. Maybe person is drawing less than 10,000 is the worker. But let's say in our cases, there are person is drawing maybe 50,000, 60,000, but still is an independent contributor. But he still come under the workman.
Yeah, definitely. I told you already. To come out of the definition of workman, if a supervisor drawing more than 10,000, he is not a worker. If supervisor less 10,000, then he is a worker. Of course, nobody is getting less than 10,000. That's not a question. Here, even a software engineer may be getting 1 lakh per month. He is a worker. Let an example, pilot of an aircraft, he gets 8 lakhs or 7 lakhs per month, but he is a worker. Right? So, nature of work is important, not the salary. Not the salary.
Okay, sir. Thank you so much, sir.
Okay.
Thanks for all your
Thank you very much. Now, I will send the test papers to you shortly. Today or tomorrow, I will request Ramesh to circulate you all. Please undertake the test, do it. And then next sessions, I think Mr. Ramesh is going to upload next 3 laws. Please make a thorough study of it. Then we'll have one more interaction session after 2 weeks. Okay?
Thank you, sir.
Thank you, sir.
Okay.
Thank you, sir.
Thank you all.
Thank you, sir.
Bye.
Thank you
Bye.
so much, sir.
All the best to
Thank
you.
you.
All the best. All the best.
Thank you, sir.
Okay.
Yeah.
Okay. Bye. Bye.